As I sit here right now, I can't remember specific conversations. I do remember that we knew that a sort of First Amendment defense would be part of the case. And I think when I mentioned to you earlier about how to frame the case, we want to make clear that this was not about trying to interfere with anyone's First Amendment rights, that this was a fraud. And as you know, under Supreme Court precedent, fraud is not protected by the First Amendment. And so in my mind, it was important to make that clear in the indictment. And that's why when we litigated this issue before the district court, we prevailed.
But the president's statements that he believed the election was rife with fraud, those certainly are statements that are protected by the First Amendment, correct?
Absolutely not if they are made to target a lawful government function and they're made with knowing falsity. No, they're not. That was my point about fraud not being protected by the First Amendment.
I mean, there's a long list of disputed elections. I mean, the election of 1800, 1960, year 2000, where candidates believe they were wronged by because they lost. And there's a long history of candidates speaking out about they believe there's been fraud, there's been other problems with the integrity of the election process. And I think you would agree that those types of statements are sort of at the core of the First Amendment rights of a presidential candidate, right?
There is no historical analog for what President Trump did in this case. As we said in the indictment, he was free to say that he thought he won the election. He was even free to say falsely that he won the election. But what he was not free to do was violate federal law and use knowingly false statements about election fraud to target a lawful government function. That he was not allowed to do. And that differentiates this case from any past history.
There's a lot of inferences and accusations being made about your bias as a special counsel's office. And I want to make sure that we rebut these in the first hour. I think it's important too. So did the Attorney General or any other DOJ official ever press you to be more aggressive in your investigation of President Donald J. Trump?
No.
Did the Attorney General or any other DOJ official ever suggest that you were expected to bring charges against President Trump?
No.
Did anyone from the White House, including President Biden, ever tell you they expected you to bring charges against Donald Trump?
No.
When you eventually did bring charges against Donald Trump, how did you make that decision? Walk us through it at a high level, if you don't mind.
Sure. It was based on the facts and based on the law. I ultimately made that decision, but I consulted with my team of prosecutors on that case, who were outstanding public servants, people with great experience in complex investigations. I took their advice and counsel in making that decision, and I tried to consider all factors, including both the strength of the case that we believed we had, possible defenses, all things of that nature.
So which based on what you just said, it sounds like you made this prosecution decision based on the evidence in the law. Is that correct?
That's correct.
What would you have done if you felt any improper pressure from a DOJ official or the White House?
I think people who know me and have known my reputation would know that would not end well. If someone tried to pressure me to move a case in one direction or the other where wasn't supported by the law, I wouldn't stand for it. And I would also say the people who worked in my office wouldn't stand for that either.
According to the Justice Department, discussion of Volume 2 of the Special Counsel's report and any information or conclusions in Volume 2 or in drafts thereof is specifically prohibited by Judge Cannon's January 21st, 2025 order. This morning, just over an hour ago, the Department of Justice sent us an email affirming its view that Judge Cannon's order applies to Mr. Smith and that it precludes him from disclosing any non-public information that may be contained in Volume 2, including, but not limited to, interview transcripts, search warrant materials, business records, toll records, video footage, records obtained by grand jury subpoenas, attorney-client communications, and potential Rule 404B evidence. This restriction significantly limits Mr. Smith's ability to discuss the classified documents case. Nevertheless, Mr. Smith is committed to doing his best to answering questions consistent with the department's guidance. And I ask that that email from the Department of Justice that was sent earlier this morning be made part of the record.
One of the strengths of our case and why we felt we had such strong proof is our witnesses were not going to be political enemies of the president. They were going to be political allies. We had numerous witnesses who would say, I voted for President Trump. I campaigned for President Trump. I wanted him to win. The Speaker of the House in Arizona, the Speaker of the House in Michigan. We had an elector in Pennsylvania who is a former congressman who was going to be an elector for President Trump, who said that what they were trying to do was an attempt to overthrow the government and illegal. Our case was built on, frankly, Republicans who put their allegiance to the country before the party. And so the president got information from people he trusted on other issues. He rejected it whenever it didn't fit him staying in office. And there was a pattern in our case where anytime any information came in that would mean he could no longer be president, he would reject it. And any theory, no matter how far-fetched, no matter how not based in law, that would indicate that he could, he latched onto that. And we were confident that we had very strong proof of that pattern. He also, I would just add, very consciously did not try to reach out to the sort of people who have the most expertise on these issues. He reached out to people who he thought could back him. Really 3 decades, I've been a career prosecutor. I've served during both Republican and Democratic administrations, and I've been guided by those principles in every role I've held. I continued to honor those principles when I was appointed to serve as special counsel in November of 2022. The decision to bring charges against President Trump was mine, but the basis for those charges rests entirely with President Trump and his actions, as alleged in the indictments returned by grand juries in 2 different districts. Our investigation developed proof beyond a reasonable doubt that President Trump engaged in a criminal scheme to overturn the results of the 2020 election and to prevent the lawful transfer of power. Our investigation also developed powerful evidence that showed that President Trump willfully retained highly classified documents after he left office in January of 2021, storing them at his social club, including in a ballroom and a bathroom. He then repeatedly tried to obstruct justice to conceal his continued retention of those documents. I remain grateful for the counsel, judgment, and advice of my team as I executed my responsibilities. I am both saddened and angered that President Trump has sought revenge against career prosecutors, FBI agents, and support staff simply for doing their jobs and for having worked on those cases. These dedicated public servants are the best of us, and they have been wrongly vilified and improperly dismissed from their jobs. I made my decisions in the investigation without regard to President Trump's political association, activities, beliefs, or candidacy in the 2024 presidential election. We took our actions based on the facts and the law, the very lessons I learned early in my career as a prosecutor. We followed Justice Department policies and observed legal requirements. The timing and speed of our work reflects the strength of the evidence and our confidence that we would have secured convictions at trial. If asked whether to prosecute a former president based on the same facts today, I would do so regardless of whether that president was a Republican or a Democrat. Recent narratives about my team's work are false and misleading, including stories about our collection of toll records. Toll records were sought for historical telephone routing information, collected after calls had taken place, identifying the incoming and outgoing call numbers, the time of the calls and their duration. Toll records do not include the content of calls. Those records were lawfully subpoenaed and were relevant to complete a comprehensive investigation. January 6th was an attack on the structure of our democracy in which over 140 heroic law enforcement officers were assaulted. Over 160 individuals later pled guilty to assaulting police that day. Exploiting that violence, President Trump and his associates tried to call members of Congress in furtherance of their criminal scheme, urging them to further delay certification of the 2020 election. I did not choose those members. President Trump did. I hope that my testimony today serves to correct these mischaracterizations about my work, and to that end, I welcome your questions.
It's pretty significant to subpoena the Speaker of the House's toll records, right?
We followed department policy and we followed all legal requirements in getting those records.
I mean, to get the information you're looking for, nobody disputed the Speaker and the President were having communications on January 6th. So one way you could have gotten that information is you could have asked the Speaker's lawyer to look at his phone records and to give you the information you needed, right?
Well, you say now that nobody's disputing, but my experience in criminal investigations is that people often at trial dispute things that you never thought were going to be in dispute during the investigation. And so when I conduct a criminal investigation, I don't assume there will be no disputes. Having a record that is a hard record about a time and the timeline of that afternoon was particularly important because that violence started. The president refused to stop it. He endangered the life of his vice president. Then he's getting calls, and not calls from Democrats, not calls from people he doesn't know, calls from people he trusts, calls from people he relies on, and still refuses to come to the aid of the people at the Capitol. That's very important evidence for criminal intent in our case.
Question about the toll records. So in this past October, in a Senate Judiciary Committee hearing with Attorney General Bondi, Senator Josh Hawley claimed that the subpoena of his phone records was, quote, tapping his phone. As part of your investigation, did you or anyone from your office tap the phone of Senator Hawley?
No.
So is his suggestion that his phone had been tapped just simply false?
It's inaccurate.
Okay, thank you.
Do you believe that the Supreme Court's decision on executive immunity constitutes an exoneration of President Trump's conduct in the months and weeks leading up to January 6th and on January 6th?
No.
Would you just explain that for us, why you don't see that as an exoneration for what he did?
Sure. I understand the Supreme Court decision. And if I just go back for a second, this was an issue we litigated in the district court. The district court agreed with us. We litigated it in the Court of Appeals. The Court of Appeals agreed with us. We litigated it in the Supreme Court. The Supreme Court majority did not agree with us. They took a view of executive power that was more expansive than what we argued. I disagreed with it for the reasons we set forth in our brief and the reasons stated by the dissent in the case, Justice Sotomayor. But it is the law of the land. And what my office sought to do in responding to that was to follow the law and see, do we still have a case? And I think the evidence that we had after that decision remained powerful. I talked earlier today about state officials who put allegiance to the country before party. Those officials from Arizona, Wisconsin, Michigan, Pennsylvania, all those I'm sorry.
Georgia.
All those witnesses, right? All those witnesses would still be available to us. The heart of our case would still be available to us. And I think it's important to know that, well, our view was that he abused his authority in the Justice Department to effect as one way to effectuate the scheme. This was about him as a candidate trying to say he won an election he didn't win. And so having to frame this in that manner, obviously it limited some of the evidence. That's why we had to supersede the indictment. But I don't think it was an exoneration because I still believed that there was substantial evidence that would allow us to prove the case beyond reasonable doubt.